The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to this argument on the Kansas Supreme Court live channel. I'd like to welcome counsel and to all of those who are viewing. I would also like to take a moment to welcome Judge Clint Peterson, who is sitting with the court this morning on this case in the position vacated recently by Justice Carol Beyer on her retirement. Judge Peterson has served as a district judge in the 26th Judicial District since January of 2009. The 26th Judicial District is a 6-county district in the far southwest corner of Kansas. In the last 2 days, we've now had judges from three of our state's 4 most extreme corners, northwest, southeast, and now southwest. So via Zoom, we're able to gather judges from all over the state. Judge Peterson has taken time from his busy docket to help us today. Judge Peterson, we are very honored to have you with us today.
Thank you.
And with that, I will now ask Mr. Doug Shima, the clerk of the appellate court, to please call this morning's 9 o'clock docket. Mr. Shima.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Thursday, October 29, 2020 consists of one case. Appeal number 121075, State of Kansas versus Michael L. Phillips. Sedgwick County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
May it please the court, Kai Mann from the Appellate Defender Office on behalf of the appellant, Michael Phillips.
May it please the court, Assistant District Attorney Matt Maloney on behalf of the state, present and ready for argument.
Thank you, counsel. Mr. Mann, you may begin your argument.
Thank you, Your Honor. May it please the court. On February 11th, 2017, Michael Phillips lived in rural Sedgwick County at his mother's home, along with his brother JR and others. The family spent the day shooting a .50 caliber black powder rifle and a 12-gauge shotgun. Later that evening, JR asked Mr. Phillips to accompany him to a birthday party as JR needed supervision per the terms of his probation. At the party, Mr. Phillips observed underage drinking and smelled marijuana, and after being unable to get JR to leave the party, went to the backyard to smoke cigarettes. While in the backyard, Mr. Phillips was approached by several partygoers and accused of talking about drugs at the party, one of whom led Mr. Phillips down the end of the driveway, told him to leave or he would be seriously injured, and displayed a handgun in the waist of his pants. Mr. Phillips appealed to JR, but JR only became argumentative with him, so Mr. Phillips left and warned JR he was going to turn him into his probation officer. After arriving home, Mr. Phillips got on Facebook where he and JR exchanged heated statements. JR eventually informed Mr. Phillips he was coming home and bringing the big ginger, which Mr. Phillips took to reference the man with the handgun, and leading Mr. Phillips to believe JR was coming home with friends to beat him. Mr. Phillips then stepped outside to smoke a cigarette and saw a white car drive in front of the home with an occupant appearing to wave a pistol out of the window. After the car turned the corner, Mr. Phillips went inside for his shoes and grabbed the shotgun as he was scared of the car. Getting back outside, he saw the car again with its window down, put the shotgun down, grabbed the black powder rifle from the garage, and fired a shot into the air in an attempt to scare the car. He then went back to the garage, loaded the shotgun in case he needed to defend himself, but intended to fire another warning shot into the air. However, when he walked out of the garage, he saw a figure rushing towards him from his periphery, which then slammed into him as he turned. At this, Mr. Phillips raised the gun and fired, striking a third person 2.5 feet to the left of Mr. Phillips, as he and his attacker fell into the fence. While the attacker and Mr. Phillips struggled, he fired again, hitting his attacker. The first shot struck JR in his right femoral artery, whereas the second struck Mr. Hooper in the left hip and thigh. Mr. Phillips then fled to a neighbor's house and called the police. JR died as a result of the gunshot. Mr. Phillips was eventually charged with 1 count of premeditated first-degree murder and 1 count of aggravated battery. The district court denied his motion for immunity, and following a jury trial, Mr. Phillips was convicted as charged. Following the trial, the district court denied his motion for new counsel based on ineffective assistance of or a new trial based on ineffective assistance of counsel, and sentenced him to a hard 50 sentence for the murder and a concurrent 50-month sentence for the aggravated battery. And this is Mr. Phillips' direct appeal from his trial and sentencing. The first issue that was raised in the brief, and the first issue I would like to start, is dealing with the appellant's motion for immunity. Mr. Phillips filed a motion for immunity claiming self-defense immunity pursuant to KSA 215231, and the district court held an evidentiary hearing. While the evidence at this hearing was largely consistent with the evidence at trial, it was presented in a much abbreviated form, with only Mr. Hooper being the only party goer and witness to the events testifying at the trial, whereas Mr. Phillips testified in his defense. However, at the end of this trial, at the end of this immunity hearing, the district court committed an error by noting that there was a whole bunch of facts in dispute, and depending on how one viewed these facts and testimony, Mr. Phillips may be entitled to immunity or he may not. However, instead of construing any of these disputed facts towards one side or the other, the district court simply found that no immunity attached. Now, in State v. Hardy and in Thomas recently, this court has recently found that when dealing with a motion for pretrial immunity based on self-defense, the district court is required to construe factual findings to one side or the other, and is required to view the evidence not in a light most favorable, without construing the light most favorable to the, without construing the evidence in a light most favorable to the state. However, in this case, is analogous to Thomas, although a little bit of a flipped result, because the district court refused to construe any facts whatsoever, but simply found the presumptions of self-defense didn't apply, that there is disputed evidence, and that immunity doesn't apply. Now, this is the functional equivalent of construing all the disputed evidence towards the state.
Mr. Mann,
Yes.
well, it looks to me in reading the transcript of that hearing that the trial judge was simply identifying all of the evidence that he found in favor of the state. Granted, he used the language disputed, but could we construe the language in his ruling as, in the aggregate, here is all the disputed evidence that supports my conclusion that there was probable cause established by the state for guilt, that notwithstanding the self-defense defense. In other words, implicitly, because he's tying that language back to the language in Hardy, which is really just the appellate standard of review of how we're supposed to construe disputed facts. So is it reasonable to interpret his findings as identifying the disputed facts that he found to be in favor of the state that supported his legal conclusion?
I don't believe so, because I believe that once we get into that implicit finding mode, then we basically end up destroying Hardy, because if the district court is allowed to implicitly decide things, it basically turns into a pleading contest where if the state presents any evidence and the court says, well, I don't know, there's evidence on the record, maybe, then we're not getting into the actual construing of the facts against one side or the other. It turns into a situation where the state simply has to present some evidence, regardless of how believable it is or not, and therefore, denies the defense, that actual finding. Because remember, the gatekeeping function of the statute is set up because the statute confers a true immunity, which is greater than a defense. This is not only stops Mr. Phillips from being convicted, but it also stops him from going to trial at all, and also stops him from having the pretrial detention. Therefore, I think that's why Hardy, and particularly Thomas and even Collins, really set home that these factual findings need to be made and they need to be construed one way or the other so we can review this. So at this point, if the district court makes no factual findings, then again, it turns into the functional equivalent of just construing all disputed evidence against the state, because the district court isn't saying one way or the other. I think that the nature of the immunity, the language in Hardy and Thomas, require the district court to go a little bit above and beyond of just noting where this dispute is. And I think once we start implying on implicit findings, that's a real slippery slope back to construing the evidence back in the light most favorable to the state.
Mr. Mann, if we agree with you and we find error, what impact does the fact that Mr. Phillips received a fairly thorough self-defense instruction at trial, and there was even more evidence adduced to his self-defense at trial, what impact does that have on our review for harmlessness?
I think it should have no effect on the review for harmlessness. I believe that when assessing this type of error for harmlessness, it's extremely important that we restrict ourselves to the immunity hearing. The state knew this was an immunity hearing. The state had the option to call all these witnesses at trial at the immunity hearing. Now, I understand the levels are different, but I mean, there's a lot on the line in these immunity hearings. Had the district court construed this favorably, Mr. Phillips may not have even had gone to trial at all. So I don't think that would be proper to supplement the evidence at the immunity hearing that the district court was supposed to construe but did not with the stuff at trial. Because again, that's the big difference between the immunity hearing and the trial, is because the trial had much more evidence, different evidence. In fact, we had a lot more of the party goers testify at trial that were not there at the immunity hearing. So I think in viewing this decision, it's important to look at this only at the immunity hearing to determine whether the error was there. And also, as I noted in my brief, I do believe that ultraris needs to be reconsidered, as this type of error needs to be considered under our constitutional standard, given the fact that Section 1 of the Kansas Constitution Bill of Rights, which protects bodily autonomy and integrity, must extend to protect self-defense.
Mr. Mann, there's no constitutional right to immunity, right?
No, but the constitutional right to bodily autonomy and bodily integrity necessarily must include self-defense concepts. And the best version, the best way to look at the statute is that those constitutional guarantees operate through the immunity, which allows, for the preservation of the right to self-defense and also the right to liberty. Because if immunity is granted, the prosecution is over. There is no pretrial supervision. There is no pretrial detention. So therefore, even if the Constitution doesn't guarantee immunity, it does guarantee liberty and self-defense. And the immunity statute just operates to provide an avenue of exercising those rights.
But there was no limitation on the self-defense of the defendant at trial.
No, there was not. But had this immunity decision been handled correctly, there's a fair chance the district court would have decided that, gosh, this is just really competing. I don't think the states carried their burden, because again,
under the statutory immunity.
Yes, under the statutory immunity, yes. And then if that was the case, then there would be no trial. And so therefore, everything that happens after the immunity is really just a product of the error at the immunity hearing.
Counsel, if we agree that we can't find this harmless because you've convinced us based on those arguments, what then would be the remedy?
I believe the remedy would be to remand it back to the district court for reconsideration upon the evidence that was already given. This was hinted at in Thomas. The Court of Appeals in Thomas, they noted that the only reason that it got sent back for a remand for a new evidentiary hearing is because the district court judge retired. I do know it's election season, and I do not know the state of the Sedgwick County judicial races, but if Judge Pullman is still the sitting judge, I think the proper remedy would be to remand back for him to make those factual findings on the record that was already presented. And frankly, as a quick aside, the reason for that, I would argue, would be fundamental fairness and basically forcing the state to stick with what they presented at the immunity hearing instead of allowing them to supplement and cover their tracks with all the other testimony that they presented. And with that, I see my time is running out. So I have no more prepared remarks.
Are there any other questions?
Just briefly, what's your best argument under if we were to agree with your argument that you have to take the snapshot of the evidence presented at the hearing when conducting a harmless error analysis, why isn't Hooper's testimony enough to establish probable cause and render any error harmless?
I found Mr. Hooper's testimony to be completely, and again, and this is why the remand is so important to go back, because I personally found Mr. Hooper's testimony to be highly unbelievable, especially when he admitted that even if he had a gun at this party, he wouldn't have admitted it because he's not allowed to have a handgun. And so once we get into that situation, which played a key part into Mr. Phillips' self-defense, the fact that there was a gun at the party, I mean, from there, it's really difficult to believe what he says. But again, that's from the record, which is why remand is necessary for the person who viewed this live to make such determinations.
Suggesting that maybe on a harmless analysis, maybe the court would have to make its own factual findings if it weren't, I mean, rather than which would suggest support for your alternative to remand.
Yes, yeah, I do think that if this court, given that the district court didn't make any factual findings, there's nothing really there to review for substantial competent evidence. Therefore, the findings need to go back to the district court who actually viewed these proceedings to make such findings, because I think doing so on appeal would just amount to weighing the evidence.
Any other questions? Thank you, Mr. Mann.
Thank you.
Mr. Maloney, you may present your argument.
Thank you, Your Honor. May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. As to the immunity issue, clearly the district court did not make a great deal of explicit findings. But in this case, as in all others, it's important to look at the totality of the circumstances, and that begins by looking at the totality of the transcript. What we see when we do that is that at the very outset of the immunity hearing, the court cited specifically the Hardy standard, including the fact that in performing its duty, that it was not to weigh the evidence with any deference to the state. The court then reiterated that standard immediately before issuing its ruling. So in the defendant's brief, and again here today at argument, what we've heard is his expressed concern that because the court did not make explicit credibility findings or otherwise resolve these factual disputes on the record, there is a concern that the court functionally weigh the evidence with deference to the state. I would submit that if this were a situation where the court had not specifically articulated the Hardy standard multiple times during the hearing, perhaps the defendant would have a valid argument that that would at least be a concern. But when
Counsel, the district, I agree with your, I'm looking at the transcript now, with your recitation of it. However, additionally, the district court said multiple times there's a disputed issue of material fact here. I mean, that was repeated at least 5, maybe more times by the district court. And then when the district court got to its ultimate ruling, the court said, as I've stated, significant material disputes exist. I find no immunity is applicable, and I'll deny the motion on that basis. Do you think that's consistent with Hardy?
I think it is consistent with Hardy. And again, that's why I do emphasize the fact that the court cited to Hardy. I think that if the court had simply noted that there was disputed evidence and then issued a ruling without making clear that he knew that he was supposed to weigh the evidence without deference, then there would be a valid concern that the court was not following Hardy. But I think that when you've got a judge saying, I'm not supposed to weigh the evidence with any deference to the state, I'm supposed to look at the totality of the circumstances and then resolve this matter. And then the court
determination, not just punt it to the jury, right?
Right. I mean,
is citing the controlling legal authority enough? Don't you have to follow the controlling legal authority?
Well, I think that under Hardy did say that the court was required to resolve the factual disputes. I don't think Hardy went so far as saying that that had to come in the form of express stated findings on the record. And so I think consistent with what Justice Wall said, I think this is a situation where what the district court did was make implicit findings, saying, I know I'm not supposed to resolve this by giving any deference to one side or the other. I acknowledge that there are disputed facts in this case. And after reviewing those facts and taking the standard into consideration, my determination is that the state has met its burden in this case.
Even
And
though
so-
the judge never said any of that.
Pardon me?
Even though the judge never said any of those things. It seems
Right,
like-
and that's why it would be, that would be why I would argue that it is implicitly done. And I acknowledge again that he clearly did not get on the bench and say, these are the factual disputes and here is how I'm resolving each and every one of those. But I think that implicit at the time that this hearing existed or took place, I think that, again, Hardy had not specifically said that they had to be stated expressly on the record. Now, I think that the Thomas case that came out just a couple of months ago is maybe a little bit more clear in indicating that the district court should make those statements or those findings on the record. But at the time that this hearing took place, I think that Hardy did allow for implicit findings. And I would argue and analogize this perhaps with a bench trial. At a bench trial, obviously the district court is empowered to make the most important determination of all, that being guilt or innocence. And yet the court is never required to resolve any disputed facts or weigh in on credibility. The court can simply say, I've heard the evidence and I find the defendant guilty as charged. And so if a court is allowed to do that, when the state has to overcome a beyond a reasonable doubt burden, and when the defendant's very guilt or innocence is at stake, I think in this situation, the district court should also be allowed to make implicit findings. And again, I certainly don't deny that it would be preferable for a judge to be express in its findings. And I think that if this court continues to adhere to Thomas, now district courts are certainly on notice that type of statement is necessary. But I do think that when you have a judge that has clearly acknowledged the standard, not only at the outset of the hearing, but then immediately before issuing its ruling, I think that eliminates the defendant's concern that this could be a judge who simply didn't recognize or appreciate the fact that he was not supposed to defer to the state's version of the facts. And that's why I do think it's so important that just citing the standard on 2 occasions, I do think that's something that we should not just dismiss and think, well, he was just simply reading something, but do we know whether he really followed it? I think that you would have to, in order to accept the defendant's argument, you'd essentially have to conclude that the court just willfully ignored the case law precedent and the standard that it had just read into the record on 2 occasions. And I just don't see that there's any reason to think that the judge would do that. Again, if the court had not cited to Hardy, then there could be a legitimate question as to whether he understood what his role was. But because he did expressly cite that, and then immediately thereafter say, I know that's the standard, I know that there is disputed evidence in this case, and I'm finding that the state met its burden, I would agree with the premise of Justice Wall's first question that was in fact an implicit credibility finding that the state had carried its burden. Obviously, moving on from that, our position would be that if the court disagrees that what happened in this case was sufficient, our position would be that any error was harmless, and I would rely on Ultreris for that. Ultreris essentially said that any error at an immunity hearing is deemed harmless if the defendant gets the full right to present his theory of self-defense at trial and if the jury rejects that. And that's, of course, what happened in this case. He was able to present self-defense without any limitations. The jury rejected it and found him guilty beyond a reasonable doubt. And so I think, and I would point out that I think in Ultreris, the error that was made at the immunity hearing was certainly greater than any error that might have occurred in this case, because in Ultreris, I believe the court actually applied the wrong standard or the wrong burden. Specifically, I think that the court might have actually been under the impression that the burden was on the defendant. And so here, we clearly know that the court was aware of what the proper burden was. He knew that it was on the state. And so any error that occurred in this case was certainly less significant or less troublesome than what had occurred in Ultreris. And so under that case law and that precedent, which we would urge this court to follow, the error was rendered essentially harmless by the fact that he was able to present his defense in full at trial.
Mr. Merlone,
Sorry, Justice Wall, go right ahead.
go ahead. I was just going to ask, what is your response to Mr. Mann's position that we reconsider the focus of the harmless error review in Ultreris, that the proper focus should really be on the error that was made at the motion hearing, the evidence presented at that time? Why is it reasonable for us to ignore that and move on to the outcome of the trial in conducting a harmless error analysis?
Right. Well, I guess I have two responses. One would be that if the defendant is in fact just arguing that this court should limit itself to looking at what happened at the immunity hearing without regard to what then happened at trial, then to me, that argument would undercut his attempt to then get the court to look at this under a constitutional standard. Because as Your Honor pointed out in your questions to counsel, there is no constitutional right to immunity. There's only a constitutional right, arguably, to self-defense. And so I think that if he's asking this court to simply limit itself to looking at what happened at the immunity hearing, then that would certainly weigh against any argument that then this court should also apply a constitutional standard. But I think the other response I would have would be that the reason why it makes sense to then consider what happens at trial in determining whether any error was harmless is that, of course, at trial, the state has a much higher burden. We have to prove guilt beyond a reasonable doubt to the jury. And part of that means we would have to overcome his theory of self-defense. And so I think it's logical to then determine or conclude that if the case has gone forward to trial and the state has been able to overcome a much more stringent burden of beyond a reasonable doubt, then logically it is safe to conclude that any error that occurred at a hearing where the state simply had to meet a probable cause burden was in fact harmless. And
Counsel, that would be true, or at least it would be compelling to me, if our focus was on the verdict. But isn't the focus of immunity on the trial, not the verdict? In other words, if the benefit of it is that you don't have to be submitted to a trial at all, then that's what we I mean, I don't know how it could ever be harmless if that's our focus. And your arguments are all focused on the verdict.
Right. Well, I think, again, I think it does. I think the two are very much connected and interrelated because, of course, if the case does go forward to trial and the verdict ends up being a guilty verdict, then in order for the state to have proven guilt beyond a reasonable doubt, I guess to give the simplest possible answer, I think the position would be that if the state has proven guilt beyond a reasonable doubt, then they've also shown that they've overcome an immunity standard that just requires probable cause.
I think that would probably, again, be pretty compelling if you could demonstrate that the evidence presented at the immunity hearing was substantially similar to the evidence at trial. Do we have that circumstance here?
Counsel is correct that there were more witnesses at trial than at the immunity hearing. But I would point, as Justice Wall did, I would point to the testimony that did come in at the immunity hearing through Cooper. And I would argue that that was in fact sufficient to meet the state's probable cause burden. And I think it does make sense that at an immunity hearing, with the standard being lower, probable cause, as opposed to beyond a reasonable doubt, I think that generally that will be what happens, is that the state will not necessarily present all of the evidence that will ultimately be presented at trial. But I think this court is still, in any given case, is still able to review the testimony from the immunity hearing and determine whether that testimony itself was in fact sufficient to meet the state's probable cause burden. And if so, then that too would weigh into a determination that any error in failing to make express findings was harmless. Just like in the context, again, to go back to my bench trial analogy, if a judge simply finds a defendant guilty without discussing any of the evidence or resolving credibility, the district court, the appellate court on appeal, is still perfectly capable of looking at the record and determining whether that verdict is supported by substantial evidence, sufficient evidence. Likewise here, the court can look back at the record from the immunity hearing and determine whether the testimony, even just limiting it to the testimony and evidence at that hearing, was sufficient to meet the state's burden to get the case past the immunity hearing to the trial phase.
Counsel,
yes.
If I understand your argument, then you're suggesting that the burden of a trial is more akin to a rebuttable presumption of harm, the presumption being overcome by the verdict. Is that what you're saying?
If I understand your question correctly, Your Honor, and please feel free to let me know if I'm not answering what you're asking. But I think, yes, I think our position is that the trial, because the burden is higher at trial, you then, it certainly does weigh in favor of a finding that any error that might have occurred at the earlier immunity proceeding was in fact harmless. And again, to circle back to counsel's argument with respect to whether this should be analyzed under a constitutional or statutory harmless error standard, our position clearly is that this is a statutory right. Immunity is a statutory right. And his argument is not that he was denied the right to present self-defense at trial. In fact, he conceded today that he was allowed to present that defense without any limitations. And so because his only argument of error is specific to immunity, our position is that that is a statutory right, and therefore it should be evaluated just under that standard rather than the constitutional standard. So just wanted to touch on that again briefly. So to summarize, our first position would be that the court did not err because it did make implicit credibility and factual findings at the hearing. The court told us that it knew what the standard was on 2 occasions. He then acknowledged that there was conflicting and disputed testimony, and then he immediately ruled that the state had carried its probable cause burden. So our position is that certainly under Hardy, as it existed at the time, that those types of implicit findings, while perhaps not ideal, were not error. We would argue that to the extent Thomas requires more specific findings, first of all, Thomas did not exist at the time that this hearing was held. We would also urge the court to maybe reconsider the need for explicit findings, because as I pointed out in the brief, the statute itself, the immunity statute, does not say that there have to be express findings. And as this court's aware, there are certainly other areas of the law where the court has said that the district court doesn't have to use any specific magic words in issuing a ruling. And I would submit that this is another one of those situations where, just like at a bench trial, the court doesn't have to use any magic formula to announce a verdict, that in this case, as long as we have specific evidence that the court understands the Hardy standard and knows that it is not to weigh the evidence in a way that is favorable to the state, then that should be sufficient. Alternatively, we would argue that any error was harmless because he was given the full right to present self-defense at trial, and that was rejected after full consideration by the jury. I'd be happy to answer any other questions from the court, but if there are none, we would simply ask that the defendant's conviction and the district court's ruling would be affirmed.
Are there any other questions? Okay, thank you, Mr. Maloney.
Thank you, Your Honor.
Mr. Mann, you reserve 3 minutes.
Thank you, Your Honor, and may it please the court. Going back to the district court's findings, the district court understood part of Hardy, because Hardy had a couple of different rulings. We had the rulings about, what I view as the more important part of Hardy, the not viewing the evidence in a light most favorable to the state, right? However, there was a secondary ruling in Hardy to where if the presumptions of self-defense apply, the district court is to look at those and apply those. And the district court in this case clearly got that part of the holding. I have no dispute whatsoever with the way they went and handled the evidence surrounding the presumptions, and the district court went through each and every one of those and specifically found it didn't apply. But then moving on to the actual evidence presented, the district court just simply said, Hardy, it talks about disputed evidence, and then it listed a whole bunch of questions it had that were in dispute, and then informed it was denying the immunity, but wanted those questions live to make sure the jury could construe them. That is not following Hardy whatsoever. That is weighing, if you just simply find disputes and define that those disputes mean that there's no immunity, then you functionally weighed all of those disputes in favor of the state.
Counsel?
Yes.
Would it have been sufficient if the court at the end of that colloquy had simply said state wins instead of motion denied?
I don't think so. Now, had the district court said, I recognize that all of these are in dispute. However, in hearing the evidence in person, I find Mr. Hooper more credible than Mr. Phillips, and therefore the state has carried their burden to show probable cause. But the district court didn't do that. It basically said, well, there's disputes, and threw up its hands while making sure that we had this to the jury. And also going back to Thomas, we're on direct appeal. So therefore, Thomas, we should get the benefit of that decision going forward, because that was decided while this case was pending on direct appeal. So it doesn't really matter that Thomas didn't exist at the time. And frankly, Thomas is nothing more but the extension of Hardy. So the district court just understood part of Hardy, but it clearly didn't understand Hardy, the actual meat and bones of Hardy. And therefore, I think that, because of that, the district, this case needs to be remanded for the district court so it can actually make those findings, and then this court would have findings to review. But at this stage, we just simply don't have the findings because the district court abdicated its role in making such findings.
Did defense counsel have an obligation to seek clarification if they were in light of the findings or the ambiguity in the findings?
I believe so, and I raised that in issue 3. I believe that that trial counsel was ineffective in that regard, and that prejudiced Mr. Phillips in the fact that a trial was had. So yes, I do, but that would be submitted under issue 3. I see that I'm out of time. I have no more prepared remarks.
Are there any other questions of counsel? Okay. Thank you to both counsel for your arguments today. We will take this appeal under advisement. I do want to note that the case originally set on the court's docket for 11 a.m. this morning has been continued. So court is now in recess until 1:30 this afternoon. Thank you.
Thank you, Your Honors.